It's waiting. I said start live.
I think we are live. We're live.
We are. Hey, Jessica, good afternoon.
Hello.
Don't sound so excited to be participating in this Facebook Live. Ha! Well, it's Tuesday. There's snow on the ground. Got to get ready for winter and how to represent our clients who are injured in accidents. And the topic today we're going to discuss on another edition of Claim Your Justice Facebook Live is public transportation accidents. What happens when someone's involved in an accident while on a bus, train, and they're injured? Remember, you could reach Claim Your Justice at 888-885-3484. Of course, you can get to us through the internet at claimyourjustice.com. And I brought up the snow because it just seems when it's snowing and colder, less people are walking, and makes sense because it's cold, and they're hopping on the bus, taking the train, therefore leading to a higher frequency of accidents happening. Trains are more packed with people, buses are more crowded with passengers. It happens. I'm happy to be joined today again by Jessica Wong Barrera. She's going to help facilitate this question and answer session. I think the format's been working pretty well. And if you have any questions during the session, please reach out to us. Jessica, let's go.
Awesome. All right, Keith, can you remind us what is the statute of limitations for most personal injury cases in Illinois?
Absolutely. I think it's interesting. A lot of people seem to know this. It's a piece of law that everyone seems to know. I have 2 years to file a lawsuit. So the general statute of limitations that apply to most cases is 2 years from the date of the accident. It's 2 years from the date of the medical malpractice. It's 2 years from the date of the slip and fall. You look at that date, you add 2 years to it, and you better file a lawsuit by that day if you're injured, because if you don't, you're prohibited from filing a future lawsuit. Now, there is an exception that applies if you're injured while a minor. So under the age of 18, we can talk about that with any clients in particular that have a specific question about that issue. Go, what do you got next?
Keith, what is different about the statute of limitations when dealing with an accident on a bus or train?
So the transportation entities, the CTA, Metra, PACE, RTA, Regional Transportation Authority, they have a unique statute of limitations that applies to accidents that they're responsible for, and that statute of limitation is 1 year. So it's 50% less time, and we all know how fast 1 year goes by, whether we're watching our kid get 1 year older, watching our legal assistant get 1 year working for us for a year. It goes by very fast. So if there's an accident that happens and you're injured, remember, it's not 2 years, because you're like, well, I'm in a car accident, a car hit us. Nope. You're on a bus, you're trying to hook the bus into liability. It's 1 year. Go ahead.
Tell us a little bit about what the common carrier doctrine is in relation to the standard of care when evaluating personal injury claims against the CTA, PACE bus, or Metra.
Good question. So we've talked in the past about duty, breach of duty. So when you're driving a friend around in your car, you have a duty to drive your car, to operate your car safely. That's your duty. That's your standard of care. When you blow through a stop sign at a busy intersection, you have now breached your duty. You've breached your standard of care to operate that car safely. When it comes to buses and trains, they're what is known as common carriers. The basic easy way to remember is you paid for your fare, you paid for their service, so you are asking them the law imposes upon them a higher duty. That is called a common carrier. And the common carrier standard of care says they owe you a higher standard of care than the passenger example that I gave you before. And so because they owe you that higher standard of care, the higher standard of care requires them to make sure that when they have you as a passenger on the bus or on the train, they are operating in basically ensuring your safety while you are a passenger on that vehicle. Whereas opposed to a driver of a car and a passenger necessarily isn't ensuring your safety, but because they undertook the transportation of you for a fare, that they have a higher standard, meaning it's easier generally to hook liability onto a bus or train operator when an accident happens because of this higher standard of care.
Besides the facts that the passenger is paying for the ride, is there another reason for the higher standard of care?
Yeah, because when you're driving and you're in control of your car, you're ensuring your own safety. So you make sure you stop at a stop sign. You don't blow through a red light. You don't do 90 in a 35-mile-an-hour zone. You, as the passenger in that example, are in charge of your safety. When you're on a bus or on a train, let's use a bus for our conversation, you're delivering to the bus driver to make sure that he operates that bus safely, because he's ensuring that what his actions are while driving the bus are ensuring your safety. That's the whole premise behind common carrier.
Anything else interesting about the passenger or common carrier relationship?
Yes, there's cases on this type of thing, on this type of issue frequently, but basically it's not just while you're on the bus or train. There's a duty that when you get on the bus, that the bus driver is maintaining the proper standard of care, so that they're going to pick you up if they're going to stop in a crosswalk and load the bus, if there's a giant pothole that they know is there, or some other foreign object, let's say there's a construction horse that fell down, it's on the ground, and the bus stops right there and is expecting you as a prospective passenger to walk over that defect in the ground or construction horse, you could make a claim that they didn't practice the highest level of safety of care for you. Also, when exiting the bus, similar example, there's lots of traffic in the city. Sometimes the buses don't stop in the exact position that they want to stop in, and you'll exit the bus, and you may exit the bus and trip and fall right into a light pole or something. And so because of those extra pieces, it's not just while you're on the bus, the bus driver runs into a viaduct, of course, that's easy, but also while getting off the bus, getting on the bus. And the standard is, until the person is completely outside of the control of the driver, the liability, the relationship responsibility still exists. So there's been cases, kind of interesting, where someone gets on the bus and they're intoxicated, ripped, and the bus driver is at the end of the route, and they let the person off the bus, and something terrible happens to that drunk person. They get off the bus leaves, the ripped person walks across the street right into oncoming speeding dump truck. Well, they may try to, that injured, seriously injured, maybe dead person now, the estate of that person may try to bring a case against the CTA to say, hey, you breached your standard of care because you didn't maintain the safety until he got into a safe environment. Well, the intoxication issue is another wrinkle in these type of cases. And if the bus, there's technical requirements, but if the bus driver knew that the person was ripped, and the bus driver knew that there was a chance when the passenger got off the bus that some further harm can come to them, there could potentially be liability against the bus driver and the CTA for that type of accident.
Makes sense. What does the CTA or any similar entities regularly assert in these cases?
So we talked about premise liability cases. Someone comes to your house, or someone shopping at a store, they walk out of the store and they trip and fall over a painted speed bump, and that's to control traffic in front of the store. And the injured person now is going to sue the store. The store is going to say, sorry, that was an open and obvious condition, and therefore we're not responsible. Well, that same open and obvious condition can be asserted and is frequently asserted by bus drivers, the CTA, bus operators. For the example I gave, someone gets off the bus, they're exiting the bus, and they could certainly avoid stepping into this pothole, but instead they step right into it. It's open and obvious. That's one example. Another example is we hear sadly in the news about passengers on trains, primarily, I've been hearing it, getting mugged or just getting their butt kicked. And then you'd want to sue the operator of the bus to say, hey, you didn't make sure that I'm safe. And the operator of the bus is going to come back and say, we are not responsible for the criminal acts of third parties. That's very common in a bus, and if that type of fact pattern were to develop, that's very similar, and that's a frequent defense in hotel cases we've talked about before, where someone breaks into a hotel room and assaults or does worse to a guest in the hotel. They're going to sue the hotel, and the hotel is going to say, we're not responsible for criminal acts of third party. I've explained how to develop those cases in the future. God forbid anything like that happens, call Claim Your Justice. We could help you with that. What else you got, Jess?
Those are all my questions for today. Thank you for answering and all this helpful information.
Great. Everyone remember, if you have any questions about your personal injury case, you want to pursue a personal injury case, if you're yourself or if you have a family or a friend who needs personal injury counsel, refer them to Claim Your Justice. Our goal is to help claim your justice. Thanks for tuning in.
Thank you.